Good evening and welcome. This is probably the 180th event that CIC is hosting, and we are very happy to welcome all of you to this session. Today we have a book release. It's a new book by Arghya Gupta, and we have two eminent panelists who have come to discuss the book, Sri Arvind Datar and Honorable Justice V. Ramasubramanian. On behalf of the Chennai International Center, I have great pleasure in welcoming all our distinguished panelists, the author, and our wonderful erudite panelists. Let me just give you a quick introduction of our honorable guests today. Honorable Justice Ram Subramaniam is a former judge of the Supreme Court of India. He was elevated to the Madras High Court in 2006 as an additional judge and became a permanent judge in 2009. After his tenure in the Madras High Court till 2016, he was transferred to the Andhra Pradesh and Telangana High Court, where he served until 2019. Elevated as the Chief Justice of the Himachal Pradesh High Court in June 2019, he was elevated to the Supreme Court in September 2019. During his tenure in the Supreme Court, he has handed down several landmark verdicts in constitutional law, environmental conservation, and financial regulation. Justice Ram Subramaniam retired from the Supreme Court in June 2023. Welcome, sir. We hope to see you more often in the CIC. Shri Arvind Datar is a senior advocate in India whose practice is focused particularly on constitutional, commercial taxation, and regulatory laws. He began his legal career in 1980 and set up his independent practice in 1984. He was designated a senior advocate by the Madras High Court in 2000. Mr. Datar routinely appears before the Supreme Court of India in matters relating to constitution, corporate, commercial tax, and regulatory laws. He also appears as amicus curiae, appointed by the Supreme Court and various high courts. He is an author, a legal commentator of note, and an expert in constitutional law and constitutionalism. Welcome, sir. We have Arghya Gupta, who is the founder and research director of the Vidhi Center for Legal Policy. He was educated at the National Law School of India, University, Bangalore, and the University of Oxford, where he was a Rhodes Scholar and lecturer in law. He is the author of two acclaimed books, Independence and Accountability of the Indian Higher Judiciary and Hameen Ast, a biography of Article 370, which was co-authored by him. He has written over 20 articles and essays in leading peer-reviewed journals and collections, including in the Law Quarterly Review, Public Law, and the Oxford Companion to Politics in India. He has most recently co-edited Working a Democratic Constitution, a special edition of the IIC Quarterly. He is a columnist at the Times of India and the Telegraph. Welcome, Arghya Gupta. So we start today's session with the release of his latest book. I request Honorable Justice to release the book and hand over the copy to Sri Arvind Datar. So with that, I hand over the proceedings to Arghya to carry on the further deliberations.
Thank you very much, Mr. Chandramouli, to Justice Ramasubramanian, Mr. Datar. Thank you very much for being a part of this book release for my new book, The Colonial Constitution. And to the audience on a long weekend, thank you very much for coming. I'm really grateful to the Chennai International Center for organizing this event. This book is just released earlier this week, and this is the first event anywhere in the country. And I'm delighted to be back at the Chennai International Center. I did the earlier book that Mr. Chandramouli spoke about on the independence and accountability of the Indian higher judiciary here as well. So I'm really delighted to be back here. Uh, my new book deals with a subject that's different from what I dealt with previously. It deals with, as the title of the book suggests, the colonial constitution. And I'm only going to say very few things right at the outset, and I hope that we can have a longer discussion during the later half of this event. So let me start with a provocation that everything you think you knew about the Constitution of India is possibly wrong. It's not the longest constitution in the world. When I was researching this book, I realized that the longest constitution in the world is the Constitution of the state of Alabama in the United States, which is 3 times as long as the Indian Constitution and 50 years older. It's We know that the distinctive feature of the Constitution of India is the fundamental rights chapter. But if we look very closely into the fundamental rights chapter, we'll find that every right is saddled with significant restrictions. Because I think that what this constitution can equally be described as is a law and order constitution. And third, is that there is a common view that's prevalent that Baba Saheb Ambedkar wrote the constitution. He certainly had a very significant role to play as the chairperson of the drafting committee, but it would be a factual error to say that he wrote the constitution. By the time he was appointed to the drafting committee in on the 31st of August 1947, Benegal Narsingh Rao already had a first draft of the constitution, which was there. The drafting committee edited it, revised it, got a lot of views of the Constituent Assembly, but certainly didn't write the Constitution. But there is a reason as to why these myths have sustained over a period of 75 years. And that is because we tend to celebrate the fact of the Constitution itself, that we know it was done in 3 years' time, and with great justification, because because the Constitution as a drafting matter was an unmatched feat. It was done in 3 years in record time. It produced consensus. And I think that what we tend to do when we are glorifying the Constitution is we celebrate the fact that the Constitution was drafted so quickly and with such great consensus. But I think 75 years later, and certainly as a legal academic, I think it is my duty to ask some hard questions. And I think that we need to look a little bit closer into the constitutional text. And we need to reevaluate which parts of the Constitution work for us and which parts don't. It's never really black and white. So that is what this book tries to do. It essentially provides a relook at the Constitution of India, particularly looking at which aspects of the Constitution work and which ones don't. In no way is it meant to belittle any of the framers of the Constitution and the work that they did. The framers included the greatest freedom fighters: Patel, Nehru, Azad, public intellectuals, Sarvapalli Radhakrishnan, Minu Masani, Frank Antony, lawyers, Alladi Krishnaswamy Iyer, Bhimrao Ambedkar. I'm getting goosebumps just saying these names. So imagine being in a room in their midst. So obviously, as there were great minds who were at work at that point of time, and they produced what Gandhiji said should have been produced, something that ensured justice to all communities with consensus. So consensus was very key for the constitutional framers, and they achieved all that. But there were certain things that they didn't achieve. It's an extraordinarily long document, and we know that despite the fact that it's not the longest, it is a very, very long document, and it's extremely hard to read. And there is a reason as to why it is long. It's because the constitutional framers felt that the Indian people were not ready for democracy. So they had to lay out in painstaking detail a lot of matters of very intricate detail. I noticed when I was doing the book that there is still a provision, Article 273, which provides grants in aid to the states of West Bengal, Bihar, and Orissa in lieu of export duty on jute. So, I mean, it's very important for the 3 states, but surely should perhaps not in the Constitution of India itself. but they wanted to lay this out in painstaking detail for citizens and political leaders to understand. But the difficulty is that it's also written in very dense legal jargon. So unless you were really mugging up for an exam, it's very hard to read the constitution as a matter of text. It's not an easy thing to do. I remember when I was in school and we had to do it in our civics classes, the constitution class used to be very boring because it was extremely long and very difficult and tedious to read. But I think there is another fundamental point which is often glossed over, is that the Constitution of India at heart is what I call a colonial document. I know Mr. Datar has some disagreements with the term, so I hope he will bring that out when we discuss it. But why do I call it colonial? First, there's as a factual matter, one third of it is taken from the Government of India Act 1935. That is a fact, that we've inherited forms of government from there. We've made adaptations, but the basic structure of our document comes from the Government of India Act. But that's not the only reason as to why I make the claim that this is a document that is heavily inspired from colonial times. The idea behind the Constitution is one of a very large state. It is a large state that is part of every citizen's lives at every moment, whether it is in relation to law and order and policing, whether it is in relation to directing how the economy will function. And in every matter, the state itself is an overriding presence and towers over individuals. Though there are several rights that are given to individuals, each of those rights comes saddled with great restrictions. And there is a reason why the framers of the Constitution did this, and I understand why they did that, because they were drafting it at a time when we were undergoing partition and there were bloody communal riots everywhere. In fact, there are one of these debates that happened in September 1947 where everyone says in the Constituent Assembly that they had to jump over picket lines and avoid some stone pelting, because in Paharganj, which was about 15 minutes away from the Parliament House, there was a massive riot. And so you can understand the impulses why law and order and preventive detention are all very live in the minds of the constitutional framers. But here's the thing, that the constitution that they were drafting was not for 5 years. Paharganj, no matter how bad the riot was, would end. And it did end in about 3 days' time. The fact is that the constitution remains. And what it did sanction was a state that has heavy powers in relation to law and order. And I think I will go so far as to say that the reason as to why we have such heavy powers with policemen in this country today is because of the fact that the Constitution sanctions that. The Constitution has a fundamental rights chapter where there is one very clear anomaly, which is that it legitimizes preventive detention. And I always find this fascinating. It was never taught to us in our fundamental rights class, but I always find it fascinating that our freedom fighters who were in jail because of the Rowlatt Act, which Mahatma Gandhi had described as the Black Act, and no civilized nation would ever adopt something like this. But when it came to our turn, we not only adopted it, but we legitimized preventive detention in the fundamental rights chapter in the Constitution. And I think that there is something to be said there, because and there's an incredible statistic that some of my colleagues at the Vidhi Center found recently, which was news to me, and I'd like to share it with you all, that in the year 2021, for which there was National Crime Records data, there were 58 lakh people arrested in India, arrested under the IPC or various criminal offences following either the process relating to FIR or private complaint. On the contrary, there were 86.6 lakh people who were detained in India without following any legal process. This is essentially the policeman just coming and picking somebody up for 2 days. It's for short periods of time, admittedly. Some of them were for 2 days. If it's a preventive detention under the Constitution, then obviously for a much longer period of time. But 87 lakh people were essentially picked up by policemen because they felt that they were some threat to law and order. Now, this is the state in which we live in today, and the fact is that this is something that, my book argues, provides some food for thought. So, where do we go with this? What is the way forward? And I think that there are two things that I suggest in the book as something that we need to think about. It's colonial, as I said, for some of the things that it contains, but it's also for some of the things that it doesn't contain. And one thing that it does not contain, and I think that this has become a political football now, but there is a deeper discussion here, is the idea of duty. where this idea of duty in the constitutional framework has become essentially a plaything because of the fundamental duties and the way it was introduced in the 42nd Amendment, which was admittedly flawed. But the idea of duty, whether you see it in a everyday sense as kartavya, or you see it in a more abstract sense as dharma, is an idea that I think requires unpacking. This is not to say that do away with rights and do away with any liberties that individuals have. But this, and I don't have an answer to this, but this is work that needs to be done in terms of how do we try and ensure duties and rights coexist. The second idea was one that was given by Mahatma Gandhi at the time and was rubbished because it was pre-modern and it admittedly has its problems, but which currently has come in a different avatar today. Mahatma Gandhi called it village government. We now call it decentralization, but it's essentially the same thing in terms of devolving power to the people. Because in India, governance structures are in such a way that they've always struck me as at odds with the population of the country. So India has a population of 140 crores. It's not really a country, it's more like a continent, because Europe and America, North America together have about 160 crores. The state of Bihar has 13 crores, and that's more like a country actually. Like Germany and Brazil taken together have about 13, 14 crores of population. The city of Chennai, I think, has about 70 lakhs, something of that nature. That's actually much more like a state. Only one state in the United States has more than that. So you see that there is something to be said about effective government in the country and the need to not think of New Delhi as the overriding power center. I find usually this has a happy reception in only Calcutta and Chennai when I make this point, and nowhere else in the country. So I will say it here. But I think that there is a sense that this is not about party politics, but there is a sense that we need to think about how to bring government closer to the people, and I think this is something that the constitutional framers didn't do. But I think 75 years later, it is something that we certainly need to think about. And all of this is not to say that we must draft a new constitution tomorrow and get all this in, but certainly we must think about new constitutional ideas and how they can develop, because we now have 75 years of experience, and I think that we should not be shy in debating some of these ideas, no matter what the political climate is at any given point of time. And when we do it, the framers of the constitution at that point of time turned to what was the accepted wisdom, and that was Anglo-American text. They looked at the UK constitution, the unwritten one, the American constitution, Australia, South Africa, Switzerland. They look at several constitutions all over the world, and they come up with the Indian constitution, which is taken from the best. But at that point of time, Mahatma Gandhi had said something interesting. He had said that to draft the constitution, you don't need to know constitutional law. You actually need to know our history and our literature. And he quoted the great poet Narsi Mehta and said that who had written the famous words, Vaishnava Janato Tene Kahiye Je Peer Parai Jani Re. And I think that there is something to be said there, that we need to look within when we are drafting the constitution. We need to look at not just Narsi Mehta, we need to look at Waris Shah, who had written that कि बुल्ला पीर मनावे ते दर्शन यार ना पावे, which is all about looking within ourselves. And since I am in Chennai, as in, we also must look at Subramanya Bharti, who had said that we must shun the fears of the unknown and we must move ahead with clear-minded purpose. If my Tamil was a little better, I would have said it, but I think it goes with already asking for apologies beforehand. I think it goes something like this: Gili Piditti Nenjinai, if I've got that right, and Telugu Petra Madinai. So Gili Piditti Nenjinai Po 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 Pet, and that's what he wrote, that let the fears go away, if I've got that right, and Telugu Petri Madinai, so va va va, and that was what he had written. And I think that there is something to be said there, because we need to have an honest conversation about the colonial constitution or the constitution we have, and for that we need to look within. So thank you very much for having me. Now I hand over to Justice Ramasubramanian.
Thank you, Arghya. I am happy that at least part of the poem of Bharatiyar was recited by you properly. Because I find it extremely difficult for me to pick up Hindi, and I find it more extremely difficult for Hindi people to pick up Tamil.
I'm not a Hindi.
He is a Bengali. He is a Bengali. That's right. It was what he said was ஒளிபடைத்த நெஞ்சினாய் வா 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 உறுதி கொண்ட நெஞ்சினாய் வா வா. But then about fear he said something else. அச்சமில்லை அச்சமில்லை அச்சம் என்பதில்லை. That was different. ஒளிபடைத்த நெஞ்சினாய் வா 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 was about welcoming a new Bharat or new India. Whatever, because Bharat, if we say, I think it's a problem now. Actually, I thought I would confine my role today to just introducing this book. What this book is about. See, all of us know the story behind the making of our constitution. I don't think if Arghya found the constitutional law class in the school boring, I found it boring even in the law college, thanks to my teachers. But the irony of fate is that whatever you find boring at an young age, I think God ordains you to develop a passion for it at a later age. So, actually, the constitution, the story of the making of the constitution was actually in 3 phases, as Arghya points out in his book. In the first phase, about 12 committees were constituted. Simultaneously, B. Narsingh Rao sent questionnaires to several people inviting their suggestions, and he collated the views of the 12 committees and presented the same to the drafting committee. Then the drafting committee finalized the draft at the second stage and presented to the Constituent Assembly. The third stage, they had discussions, and ultimately we had this final draft which was adopted by the Constituent Assembly. It was not as though we had everything rosy in our way, when we did this constitution. We had a lot of problems. The country was divided by at least 6 ethnic groups, 8 different people professing at least 8 major religions of the world, people speaking about 1,600 languages or dialects, whatever it is. It was so divided that for a cohesive country to prepare a constitution which is acceptable to all was an extremely arduous task. It was not a homogeneous society in any one sense of the term. That was the challenge that the Constituent Assembly faced. In fact, when the Constituent Assembly was entrusted with the task, Winston Churchill had very, very damaging words to say about the Constituent Assembly. He said, the assembly was dominated, Winston Churchill said, assembly was dominated by one major community in India, the caste Hindus. He said, the Congress was not a truly representative party, but rather a mouthpiece of actively organized and engineered minorities who, having seized upon power by force or fraud or chicanery, go forward and use that power in the name of vast masses with whom they have long since lost all effective connection. This is what Winston Churchill about the Congress in 1944 or so. But you should remember that 8 months before the Constituent Assembly was convened for preparing a constitution, something similar, a similar exercise was being undertaken in Japan. What happened there was a new constitution was presented to the Japanese parliament called Diet. This document was wholly written by a group of foreigners. In the early February 1946, 24 individuals, all of whom were Americans and 16 of whom were military officials, met in a converted ballroom in Tokyo. They sat for a week before coming up with a constitution they thought that the Japanese should adopt. This was then presented as a fait accompli to the local political leadership, and any amendment that they wanted to make has had to have the approval of these 24 Americans. That was the constitution that Japan got. Look at, take this in contrast to what happened in our country. The Constituent Assembly, much to the chagrin of Winston Churchill, comprised of people drawn from various walks of life. That is why Grenville Austin, he termed the framing of the Constitution as perhaps the greatest political venture since that originated in Philadelphia in 1787. So it was not a very easy task for the Constituent Assembly to come up with a panacea for all diseases. This is something which we should really keep in mind. Now, it is in this backdrop that we will have to see what this book talks about. To put it in simple terms, this book, Colonial Constitution, is partly a book of history, partly a book of constitutional law, partly a book of the story of the making of the Constitution, and partly a critique of the Constitution for its lack of originality. He calls it as something that lacks originality. The book says in a gripping narrative 4 things: what happened, how it happened, why it happened, and also what should have happened. That's all the book is about. Normally, the message that an author wants to convey would be presented in the preface or in the introductory chapter. So many of us, people like me who are very fast readers, I used to read the introduction or the preface and then go to the last chapter, because I don't have the patience even for watching a 90-minute movie. I will fast forward and go to the end and see the climax because that's what is called in Sanskrit Phalashruti. So if you open this book and see what the author wants to say, you will not find it. He has played a trick on the reader. So you will have to go to the last page. I just read out, because any misgiving that the title of the book gives would get dispelled by what Argya says in page 216. That's the last page. I just read out. This is not a call to draft a new constitution today. We live in polarized times, and any constitution that emerges out of such a time is unlikely to be long-lasting. But it is a call to think more deeply about the constitution rather than merely extolling its virtues in a rhetorical fashion or criticizing it unthinkingly. The Constitution creates a towering state that stifles individual initiative. He already mentioned about it. It creates big governments that diminish the role of local communities. It gives citizens fundamental rights but hedges them with a slew of restrictions. At the same time, it spells out a clear vision of a more equal, secular, democratic India with free and fair elections based on universal adult franchise. If India is to prosper, it needs to embrace some of what the Constitution has to offer: the promise of freedom, communal harmony, and equality. Equally, it has to reject some other bits: preventive detention, rights without wrongful duties, a colonial state which over time has become a rent-seeking one. India today needs an honest conversation about its colonial constitution and whether it is ready to chart its own constitutional course. The time for banal homilies is over. So that sums up what this book wants, what he wants to say through this book. There are a lot of things about this book. I will only mention one thing before I hand over the podium to Arvind Datar. This book also discusses, I think for the first time, I don't know, I have not read anywhere else, the different models that were available at that time. Alternatives that were there were a lot of people who came up with a lot of alternatives. For instance, Gandhi came up with an alternative model. Not really an alternative model, he came up with his own ideas of what a constitution should contain. Of course, some of his ideas bordered on romantic idealism. I always used to think Gandhi is condemned today because of his idealism. Because we don't want ideal people. We don't live in an ideal society, we don't want ideal people. Ideals are to be shunned if we have to be successful in life. So the first model was by Gandhi, that was written in his book titled The Constructive Program. What Gandhi wanted as a model is described in this book, The Constructive Program, about which there is a very brief mention in page 119 and 120. I'll just read one paragraph, very interesting, what Gandhi actually wanted. The constructive program was a social manifesto of sorts, with the duties assigned to every individual, which, if executed, would lead to India attaining complete independence by truthful and non-violent means. The duties encompassed 1 hour of voluntary daily labor. We can't adjust it, appropriate it against morning walk. The duties encompassed 1 hour of voluntary daily labor, men treating women as equal comrades in service, the rich taking care of the poor, adhering to the doctrine of trusteeship and such like. There were also rules of economic organization, self-sustaining villages with khadi as the primary industry supported by other cottage industries like soap and matchmaking, a supplement to nationalized industries with constructive and non-violent labor unions, of cultivation of civic virtue by keeping one's villages clean, and of orienting education towards creating model villages and citizens. Very, very fanciful idea. This was one model that was presented by Gandhi. There was another model, interestingly, presented by a very tiny princely state called Aundh. That tiny princely state of Aundh the Maharaja created in 1923 a legislative assembly. The Maharaja created. In fact, today legislative assemblies have created Maharajas. But in 1923, a Maharaja created legislative assembly. In 1938, a charter, something like a constitution, was presented to the Maharaja, this Maharaja of Aundh. You know by whom? A Polish Jew by name Morris Friedman. Argya has written about this, only one portion. Morris Friedman was a very fascinating personality. He was a Polish Jew. He became a very ardent disciple of Nisargadatta Maharaj. He has authored that book, I Am That, Tattvamasi translated into I Am That. You know, something very interesting happened. We should not always talk about constitution. We should also talk about something else. You know that Morris Friedman was on his deathbed. When the other disciples of Nisargadatta Maharaj cried, thinking that Morris Friedman was going away, his life was ebbing out. Suddenly this man stood up, he sat and said, Arey, why are you crying? I am very happy to go away because the body has become like a very old and worn out shirt. What do? You don't wear the same old shirt every day. You know, once a shirt becomes dirty, torn, you shun it and take a new cloth. My soul is fed up of this body, therefore I am shedding it. I am happy going away. Why are you crying and making me unhappy? So he said it, he drove all the other disciples away and he shed his mortal remains. That Morris Friedman prepared a very small charter. Actually, that charter contained very detailed prescriptions. That was the second model. Then there was yet another person by name Sriman Narayan Agarwal. He prepared something like a constitution on the models on which Gandhi advocated. But Gandhi actually dissociated himself with the document prepared, though he appreciated the efforts taken by Narayan Agarwal. The fourth is a very interesting piece of document. Many of you may have different ideas about Savarkar and Hindu Mahasabha. But Hindu Mahasabha, on behalf of Hindu Mahasabha, a constitution was written. Interestingly, the constitution contained the constitution prepared by Hindu Mahasabha was is almost similar to the present constitution which our Constituent Assembly has adopted. Nobody would have expected it to be so. It was a very tiny document, 56-page document containing 111 provisions. What was so surprising about this document is captured by Arghya. I'll just read only one paragraph and I'll conclude. The most intriguing element where the constitution of the Hindustan Free State, Savarkar, in Hindu Mahasabha, described this constitution as constitution of the Hindustan Free State. The most intriguing element where the constitution of the Hindustan Free State broadly matched the eventual constitution of India related to the freedom of religion. With Savarkar's well-established understanding of Hindutva as the basis for a future Indian nation state, there was no real place for Muslims, Christians, Jews and Parsis to be equal citizens in such a state. It might have been expected that the constitution endorsed by the Mahasabha would incorporate such an idea. This might have taken the form of two classes of citizenship with preference given to those adhering to the Hindu faith. But the constitution of the Hindustan Free State contained none of these ideas. Instead, it provided freedom of conscience, free profession, and the practice of religion for all. Further, it guaranteed to every citizen the protection of their culture and language subject only to public order and morality. The state was also prohibited from discriminating against anyone on the basis of their religious beliefs or status. Religious instruction could not be forced on anyone in a school receiving public grants. This was by Savarkar in the Mahasabha. Finally, it was categorically declared that there would be no state religion in the Hindustan Free State. This restricted religion to a protected private sphere and foreclosed the possibility of a constitutional Hindu Rashtra. This is page 159. So all of you have the book with me. So fortunately, I came with preparations. Otherwise, I would have been put to test. In fact, he should be put to test for writing this, not me. But finally, one word of caution. Actually, at the time when the Constituent Assembly adopted the Constitution, a warning bell was rung by the chairman of the Constituent Assembly, that Sachiranda Sharma. He said something very interesting. I think that still holds good. He said, he quoted American jurist Joseph Story saying, I quote, "The structure has been erected by architects of consummate skill and fidelity. Its foundations are solid. Its compartments are beautiful as well as useful. Its arrangements are full of wisdom and order, and its defenses are impregnable from without. It has been reared for immortality if the work of man may justly aspire to such a title. It may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. Republics are created by the virtue, public spirit and intelligence of the citizens. They fall when the wise are banished from the public councils because they dare to be honest, and the profligate are rewarded because they flatter the people in order to betray them." This is what he said. Therefore, whatever be the constitution, whether it is colonial or otherwise, it's given to us to work it out. If we are determined, then no constitution in the world can tame us. Thank you very much.
Sir, you have to increase the volume.
Honorable Justice Ramasubramaniam, my friend Orgo, ladies and gentlemen, thank you so much for attending this program. It's always a pleasure to be back at Chennai International Center. Well, the Ganesh Chaturthi holidays were spent reading the colonial constitution. As Orgo said, I have great allergy to this constant reference to colonial legacy, colonial this and colonial that. I would not call it a colonial constitution. I would call it an international constitution. And why do I say I would call it an international constitution? Because first of all, nobody foisted this upon us. It was our choice. And if you see the Indian Independence Act, in fact, Pandit Nehru said that we will not accept anybody's constitution. We will write our constitution ourselves. We don't want anybody else to write the constitution. Initially, that was not accepted. Then I don't want to go into this Cripps mission and so on and so forth. Finally, when the Indian Independence Act was made, I think Section 8 or Section 7 says that the Dominion of India and the Dominion of Pakistan will make their own constitution. Of course, by that time, the Constituent Assembly had already started. The Muslim League boycotted it, as you know. And then, after the midnight of 15th August, the Constituent Assembly reassembled and they continued. We all know it's an indirect election, how people were elected indirectly and so on. But why I say it's an international constitution and not a colonial constitution is, the Government of India Act came in 1835. And if you want to study, you must start with the Government of India Act of 1800 and how it went on and on and on. You had the 15 Act, 19 Act, and finally the 35 Act. As more and more the freedom struggle moved on, and people's aspiration was to get more independent, finally they decided to have the Government of India Act. It is a very well drafted act in the government for the governance of a complex state. Let us also not forget that the Government of India Act basically covered only 28% of the territory, because most of it were princely states. But nevertheless, it covered what was called the Governor's Provinces and the Chief Commissioner's Provinces. And this was the Government of India Act. Now, if you see the debates, why I say it's international was, you had an act which worked for 11 years, from 1935 to 1946. As Orgo put it, that you had absolutely, as you say, when you read the roll call of people who were in the Constituent Assembly, it is absolutely, we feel very proud that these were the intellectual giants were there. Sir Aladi was there, Gopal Seva Iyengar was there, Kamath was there, Kunzru. Then you have so many other names which I keep seeing when I read all these debates from time to time when it comes to a case. And it will not be fair to say that, strong to say that the intellectual capital that was contained in the Constituent Assembly has not been matched ever since in our independence. Let's face facts. Now, and if you see the menu, the so-called menu which is given by Sir B.N. Rao, and he sends a questionnaire, and he leaves it to you. He says, look, what shall we do? Shall we have the presidential form of government? Shall we have this? Shall we have that? And then in the menu, if you see, he has given, this is the position in Ireland, this is the position here, this is the position here. And based on this question, ultimately the constitution was drafted. And if you see, the reason I call it an international constitution, and I don't like the word colonial constitution, is that this is an amalgam, not only from the Government of India. See, the Government of India gave us the governance model. They said that there's a union, they what they call the federation, then they got the provinces. They had the three lists between the federation, the province, and the concurrent list, which ultimately came from the Canadian Bainey Act and so on. But when they drafted the constitution, you find debate after debate. When it came to fundamental rights, they took it from the American Constitution. When it came from directive principles, it came from Ireland. When it came to some parts of the emergency provision, it was from the German Constitution. So these are all the way the amalgamation, they came and they made it. Now, the book says that they did not take into account certain Gandhian principles which were there. I have my doubts as to how these Gandhian principles could have been adopted. Then I further say that you say that they didn't take into account the village model, the panchayats and so on. But we ourselves introduced the panchayat model in part 9 in 1993. The municipalities came 6 months later. But if we don't implement the panchayat and municipalities, what is the point in blaming the colonial constitution? They never said that don't have a panchayat. We decided to have the model. And of course, there are debates which say that keeping in mind the period at that time, when Pahad Ganji mentioned, the riots, the partition, the Holocaust of partition, all that was in the background. And in fact, when you see Sardar Patel's exhortation to people not to object to 370, they said it's a temporary thing. Please let it go because we are coming to such a position. Similarly, his very, very passionate plea of giving the princes the privy purses. was also very, very important. So all this ultimately came into the constitution. So I would first of all say it's an international constitution. One thing I liked about the book was, of course, as just Ram Sonam pointed out, this Hindustan concept. In fact, I have not had the chance to read the 2 volumes of Vikram Sampath's book. My wife has been telling me to read it. But I was very surprised to see that this is what I must compliment him on the enormous research that has gone into this slim book. What was very, very touching to me was the treatment of Dr. Ambedkar in Baroda. My in-laws lived in Baroda, so I got married there and my children were born there. And I used to keep going to Baroda for so many years. At that time, my father-in-law told me that Maharaja Sayajirao was supposed to be a very enlightened ruler. And I think his Diwan was Sir Madhav Rao was his Diwan, if I'm not mistaken. He had a system of sending people to scholarships. And it was his scholarship that took Dr. Ambedkar to Columbia University. And if you read the Mandal judgment, in Justice Jeevan Reddy's judgment, he quotes certain passages that he wrote about caste and so on in 1912. Fascinating. And I was told by my father-in-law that the system was so abhorrent. I mean, just please read this book. It really gives you goose pimples or makes you shocked that something would happen like this. Nobody would give him a house. He had to stay in a Parsi house by taking a false name. When they came to know his real thing, those Parsis asked him to go out. This was the kind of system. And the only analogy I could see is, if you read the biography of Powell, who was the first African-American Secretary of State, after Colin Powell, after passing from West Point, which is a premier institute, he would not get housing accommodation in the US. And ultimately, of course, he became a 4-star general and then became the Secretary of State. But this was the point. And I remember almost 30, 40 years ago, somebody told me a story of Dr. Ambedkar in Baroda. I believe that he was an officer in Baroda, but the clerk, who was a caste Hindu, who would throw the file like this. They would not hand over the file to him. That was the kind of treatment they had. And I believe he remarked, tongue-in-cheek, and of course, the shocking thing was, I never knew, but thanks to Orgo, ultimately he had to go and live in some park in Bombay because no housing would be available to Dr. Ambedkar. So you can just imagine the angst of the man and why the provisions he made for the scheduled castes and so on. But one interesting point in all this was, he remarked when the constitution was made, he remarked that, look, when people wanted the Ramayana, they had Valmiki. When they wanted the Mahabharata, they had Vyas. When they wanted the constitution, they had me. Meaning in all cases, there was no upper caste person who did that. That was a remarkable thing. And I particularly find, and those of you who are interested, just see his speech on the 4th November 1948, when he makes the speech justifying why it's a long constitution. And it is for the first time that he uses the word constitutional morality. So I think Orgo has brought out very well the origins of the constitution, how it came to be drafted. And I part ways in calling it a colonial constitution. But apart from that, that research is truly commendable. I'm also very glad that you did not say basic structure has to be revised, because that is now the most fashionable thing to do, you see. In fact, I had the privilege of delivering the P.D. Desai Memorial Lecture this year at Ahmedabad. And he was one of the greatest judges we had from the High Court. In fact, just to tell you a story, I had gone to meet Chief Justice A.P. Shah was our High Court judge. And there was a portrait of a person on his table. So I said, sir, is this your father? He said, no, this is P.D. Desai. And he said, this is the man I respect most. Yes. In Chamber had the portrait. And P.D. Desai was a Chief Justice of Gujarat, of Bombay, of Calcutta, but he refused to go to the Supreme Court because he was superseded once. And to the credit of the man, after retirement, he did tremendous work for the rehabilitation of the Narmada people, took 1 rupee a month salary and only took car and petrol to go from village to village. So that was the thing of P.D. Desai. Anyway, the point is, when I did this P.D. Desai Memorial Lecture, I spoke on the basic structure. And I was surprised to see so many people. You mentioned about the old cloth. They said, look, Constitution is 75 years old. Is it not time to relook at it? Is it not a time to relook at the basic structure? And I asked the simple question, and I've asked this question in so many seminars and debates. From 1950, we have this Constitution. The basic structure came in 73. because you wanted to destroy the constitution. And to the credit of the Supreme Court, it was saved by 7 judges out of 13. And I at least hope in my lifetime we don't have a situation where a bench of 15 is constituted and 8 people reverse it and we go back to the place. It's very simple. You just require 8 people to tilt the balance and go back to old days. But these 7 people say the basic structure. And when I attend so many seminars, the standard thing is must have a relook. Companies Act has become old, relook. Income taxes have direct taxes scored. You keep on having these things, but ultimately at the ground, nothing really changes. Now, coming to this colonial constitution, what I wanted to mention, because we're going to have a panel discussion also, I just wanted to mention that not one person has told me so far which provision of our constitution is an impediment either to economic progress or to social progress. Nobody is able to tell me so far. In fact, we had the right to property that was taken away. And as we'll discuss later, preventive detention he mentions in the constitution, very unique. This is the only constitution which has preventive detention as a part of the constitution itself. And there's a lovely passage, part of fundamental rights. And if you read the A.K. Gopalan's judgment of Patanjali Shastri, I knew the passage by heart, but I forgot it now. Patanjali Shastri, they say, how can you have preventive detention in a chapter on fundamental rights? It is a paradox. It's a contradiction in terms. But Justice Patanjali Shastri puts it beautifully. He says, this sinister provision, so out of place in our noble constitution, is doubtless necessary to meet the problems of the day. Because at that time, my grandfather told me there was so much of communist movement, labor unrest, partition problems, caste problems, and so on and so forth, that this constitution was necessary. I'll not go further. He also mentioned about fundamental duties, kartavya. Now from Amrit Kal, it's become Kartavya Kal. And as why are we trying to emphasize on duties? Is it because you want to tell people that don't emphasize on your rights? You're going to have lesser and lesser rights and you're going to have more and more duties. I don't know what is the objective of saying that. And I'm rather, I don't know if there's a pattern to what is happening around, India and Bharat. I wrote an article in India Today on India and Bharat. Now there I want to mention that this question of Bharat, you either say Republic of India or say Bharat ka Samvidhan, Bharat ki Ganarajya. You don't say the Chancellor of Deutschland, you say Chancellor of Germany. So my point is, it should be, if it's Indian, keep it as an Indian name, Bharat ka Samvidhan. As I said, in the constitution, the word Bharat comes once. There are 550 times India used, only once Bharat is used. Go to the Hindi version, India is used once, Bharat is used 550 times. So don't mix up the two. And that's again my problem with this IPC, CRPC and if you want to have an English law, keep an English title. Don't put Bharat Nyaya Samhita, just call it Indian Penal Code. That's my basic problem. So when you talk of the colonial constitution, the way to reject this colonial thing is not by changing names from Trivandrum to Thiruvananthapuram and so on. The problem is to solve greater problems. And Orgo said that, I'll just, like Justice Ramswaran said, I have the same thing. I try to see the first and then I see the end and I see the acknowledgements in the book. Unfortunately, since I write books, I don't have the liberty of seeing only the conclusion of the judgments. I have to necessarily wait through 180 pages of decree. Yes. But I'll just mention one thing, Orgo, and I'll conclude. You mentioned that this is not a call to draft the new constitution. That was a very, very heartening thing. And he said that it's time to think about the constitution. My suggestion is, let us devote only 10% time to think of the constitution and think of 90% time how to solve the problems within the framework of the constitution. If a company is doing very badly, then the solution is not to amend the memorandum articles, check the management of the company. Thanks.
So thank you very much, Justice Ramasubramanian, Mr. Datar. I think the organizers now have many ideas for future seminars in Mr. Datar's speech, basic structure, names changing, but I think we can keep some of that out today. Since we've spent a little bit of time discussing the origins of the Constitution, and both of you have operated the constitution on a daily basis, almost as lawyers and judges of our superior courts, I'd like to take it to one or two issues that we deal with, that I deal with here, and then open it up for questions given the paucity of time. So first, I'd like to come to one part of the Constitution, Justice Ramasubramanian, that is fairly overlooked and seems today like an anachronism, which is the directive principles of state policy. At the time of the formulation of the Constitution, it was a fairly novel idea because constitutions deal with only political democracy. Here was an idea of how India would be an economic democracy, whether we agree or disagree with the direction that was taken. But in today's day and age, as written in another newspaper column where I have to pay 85,000 rupees per month for my 2-year-old son's Montessori school, and it costs 2,000 rupees to get a haircut at a salon. We have a constitution that in the preamble declares us to be socialist, and also in the directive principles chapter that calls about material distribution of resources for the common good. So how do you see this directive principles chapter as having aged over time, particularly your experiences in court?
No, but actually, at the time when the debates took place, they divided this into two types of rights. One, justiciable rights, and another, non-justiciable rights. If nobler objectives dictated the preamble, the pragmatism dictated where it should be incorporated. If the rights contained in the directive principles of state policy had been made part of the fundamental rights and became enforceable in law, the state would have had to share a huge financial burden, which they thought it was not possible. In fact, this Veer Savarkar's, you have mentioned the draft constitution, he has made all these rights enforceable in court. Because nobody asked them a question, how will you do it, where is the money? Because if I am not going to operate the constitution, I can really say anything I want. Like freebies. That's right, freebies. See now, but over a period of time, the courts have come to the rescue of citizens by tweaking some of the directive principles of state policy into fundamental rights. For instance, how did we get Article 21 capital A? So therefore, by a proactive measure, this is one of the things that I used to say that courts have also done some good things. So Mohinigiri, Article 21A came. So slowly, through a back door, what was not let in through the front door was let in by the court through the back door. Because we were expert in...
So would you like to add anything?
No, I would just tell just Ramasubramanian, the courts have done a lot, and there's no doubt about it. In fact, I keep telling people that if 80,000 writ petitions are filed in Madras and Madurai, it shows that for the vast majority of people, the judiciary is the only place where they can go. And I can say that in practice, courts have been very proactive in trying to implement directive principles. You mentioned about 21A. And not only that, I think they have also read 21 into many of the directive principles are brought in as a facet of life and liberty, environment, minimum wages. Though they are part of directive principles, they have said that right to wage is part of life, part of liberty, and so on. So that way, a lot of implementation has taken place.
Actually, that's a very interesting point, because if you also see the founding of the Constitution, as Justice Ramasubramanian was saying, that they were all part of one large chapter, and then this separation into two chapters happened later. And it was interesting that one of the things that was listed as a non-justiciable principle in the first draft was equality, was what we know as Article 14 today. That was actually seen as a non-justiciable directive principle. Patel said in that advisory committee on fundamental rights that equality is so central that we have to bring it here. I'm not listening to the lawyers. I mean, he himself was a lawyer, but I'm not listening to the lawyers in the committee on this one. So that was interesting. But one place where the lawyers did have their sway, Mr. Datar, is in relation to Article 21 of the Constitution, life and personal liberty. We know the whole story in relation to Justice Frankfurter and why we ended up with the word reasonable procedure established by law and not due process of law. Now, we know that this essentially, and particularly for those who are not from the legal fraternity in the audience, what this has allowed is the state, in some sense, to pass several laws that restrict liberties of citizens. And this is across party lines, that there has been no government that wants to get rid of a provision like sedition. No government, irrespective of which party they belong to, because the constitution does sanction it. And the judgment of the Supreme Court in Kehar Singh as in upholds that. So the question that arises is that in terms of life and personal liberty, so you can go for life and personal liberty, the difficulties of getting bail on an everyday basis in court, the number of cases that you find where policemen are slapping cases of sedition or other unlawful activities under the UAPA. How much do you think that this is attributable to the fact that we have large leeway that is given to the state under Article 21, and how much of it can we attribute only to some malevolence of a local policeman?
Very interesting point is that in the ADM Jabalpur case, they said that you can't approach the courts at all. Even if your rights are taken away, you can't approach the courts. Of course, they went one step further and they said that you can't even say that I've been detained wrongly under MISA. Now, in the 44th Amendment, they made sure that even in an emergency, you can't suspend the right to life and liberty. So the Constitution says that whether the country is in a state of emergency or it's in a normal state, your right to life and liberty is protected, enshrined, nobody can take it away. But the difficulty, what I find is that if Vidhi can make a study, we have more and more laws which permit preventive detention. As you mentioned, shockingly, I did not know it's 85 lakh people are detained like that. I don't know how much are through preventive detention, but yes. But when you study UAPA, when you study so many laws, while you have made Article 21 as permanent and inviolable at all, at the same time you have statutory laws which make it impossible to get bail. Now, I don't know of any country in the world which says that you can't get bail unless you can show that you're likely to win the case. This kind of provision is not known. And in fact, those of you who want to, a very interesting case on where I think I would, with all due respect, lay the blame on the Supreme Court for not going far and striking down these provisions which say that, we had this Vijay Mohanlal thing where the PMLA was Vijay Madan Lal case where they have completely supported very, very draconian provisions. And I'll just give one example. It's a brilliant judgment of the Privy Council. Mauritius, the Constitution of Mauritius, Section 1 of the Constitution of Mauritius says, Mauritius is a republic governed by rule of law. That's all. They made a law saying that for narcotics and drugs, courts shall not grant bail. All right? That was challenged by the Mauritian court, struck down, went to Privy Council, struck down. You know on what ground? The Privy Council says, arresting a person is an executive function. To grant or not to grant bail is a judicial power which can never be taken away. If it's a country ruled by the rule of law, then the power to grant bail can never be taken outside the courts. But right from Kartar Singh and so on, we have always, on the excuse of public interest, terrorism, etc., we have tried to. So on Article 21, my point is, it's a paradox that though the Constitution makes it sacrosanct, our own local laws have slowly and surely eaten it away and made it more and more difficult to get bail.
So I think that's a good segue to talk about the future, because I think we've discussed the origins and also the operation. Maybe a word about the future, because this is something that I haven't dealt with in my book, as Justice Ramasubramanian pointed out, and I've only given some hints of where I think it could go. Of course, this has much to do with the memorandum and articles and not the management. I think we have many discussions about the management of the company. But I think on the memorandum and articles themselves, and Justice Ramasubramanian, I'd like to ask you, since you are, if not the most knowledgeable person I know about in the legal fraternity on ancient Indian culture and history.
I said you are very knowledgeable. You are exposing your ignorance.
Is that how do you see ideas particularly ideas in relation to duties coexisting with rights. Let me put it simply, because I think no one's case for a constitution that has duties is to say that there will be no rights. I don't think that is a case that can be made. And that is a straw man. So how do we see the idea of duties within a constitutional framework?
See, the difficulty with duties is, where do you enforce them? We are not able to enforce duties upon our own children. Teachers are not able to enforce duties upon the students. The society has come to a stage where, each individual has become an island. The enforceability of duties upon individuals, whether it is personal duties or social duties. We have, after all, social contract theory. All of us live in a society where each one, owes something to the other, and the question of coexistence is. But enforceability may be a problem. In fact, in one of the seminars, somebody asked me, the constitution has become bold. I said, all right. Has become very bold. I said, it's all right. I am prepared to select five of you, appoint you as the drafting committee. You come up with a new constitution. Then they never turned up for the meeting. So the task is actually difficult when you sit down to pen details. When ideas are, mind is very fertile. It comes up with a lot of ideas. But when you pen down all of the ideas into real, you provide a structure, it becomes extremely difficult. So my problem is Gandhian ideas were good, actually. But enforceability of duties, I don't think, where will you enforce them? Courts are not the places where, to some extent, courts can penalize an individual. For instance, you have this Maintenance of Parents and Elders Act. If properties are taken away by the parents, and then parents are not maintained, parents go to court and get back their property. That is not the way of enforcing the duty upon the children. It's one way of penalizing or getting back what they lost. So this is a very, very tricky area.
This question of right and duty is, in the Hoffeldian sense, you say that every right has got a corresponding duty. Maybe what they say, I just think that when you say I don't want to get into fundamental duties. I have still not understood why Swaran Singh committee recommended fundamental duties. It's like telling a child, you shall do your homework, you shall do this. We know that. You don't have to tell us. But fundamental duties is a chapter in the Constitution. But what right and duty, perhaps I think it's John F. Kennedy who says that the right to free speech carries a corresponding duty to think before you speak. So maybe in that sense, they say that if you get a right, then before you exercise that right, you have to have a duty to think. So,
really think they won't talk.
Yes. So maybe in that sense, the right-duty correlation could be important, that with great freedom or with a large amount of rights also carries a corresponding duty to think about those power, how you exercise it and so on. I don't know if you can think in those terms.
One area where probably this can be developed is the area where we have civic duties. See, for instance, in Singapore, we all talk about Singapore being clean. You can't throw anything on the road unless you invite a penal consequence. Here, the whole country is, we treat it as a dustbin, except our house. Other than my house, all other places are dustbin where I can throw everything. Though that is probably where the duties can, I'm not able to immediately visualize any other area where duties can really be enforced except through penal provisions.
So one last question, Mr. Datar, and then we'll open it up. Because Justice Ramasubramanian mentioned that how difficult it is to actually be a new drafting committee, but it was tried with the National Commission to review the working of the Constitution, headed by Chief Justice Venkat Chalaiya. A very eminent body was set up in order to do this task, and they made a whole range of recommendations. But of course, even at that time under Vajpayee's government, there was not enough consensus across the board, so that that project was shelved. Now, and there were many recommendations made, particularly on topic we were discussing before on judicial appointments. There was a recommendation made. There were interesting recommendations made on right to recall elected representatives if they are not performing, which is I think an idea whose time has come. But be that as it may, so if there were to be a body with a person of the eminence of Chief Justice Venkat Chalaya, as in what are the things that you think are things that are worthy of rethinking because it's 75
Yeah,
years?
I think first thing rethink is the 10th schedule on this. What in fact the 4th November 1948 speech of Dr. Ambedkar uses for the first time the word constitutional morality. And we talk of constitutional morality. In fact, I don't know when the Chief Justice is going to constitute the Sabrimala bench before 7 or 9 judges. And I think we have divided the work, and it's my lot to argue on constitutional morality. 10th schedule is a classic case of constitutional morality. You had this Ayaram, Gayaram thing where people would wholesale defection, so that was checked by 10th schedule. Now, they never contemplated that within one party there will be a defection. So, the original party, parliamentary party, that's one area. Second area which I was thinking about it, what needs to be done is Article 282, where they say that monies can be spent only for public purposes. And that's a big problem on freebies. You see, Mr. Shivaraman is here, he's been, I think one thing which will really, really hit us badly is this thing of giving endless amount of freebies. You just can't sustain it beyond a point. What happens is you govern badly, and if you want to come back to power, only thing you can do is I'll give 2,000 rupees free to a lady, I'll give 4,000 to a child, give 1 lakh for a laptop. It just goes on. I argued very unsuccessfully before the Supreme Court in that Subramaniam Balaji's case that free laptops, free thalis, free this, free that. And I said that there are 3 US Supreme Court judgments which I quoted, they didn't follow it. They said that public funds can never be used to create private assets. You can use one computer centers, make it for the schools, make it for the community, but you can't say I'll give free laptops, this and that. So I think Article 282 can be amended. I also want to say that giving such freebies should be taken as a corrupt electoral practice. Otherwise, I think we are going to go into, if you just see the statistics, go to the website of Telangana, go to the website of Karnataka, the only achievement of the government is how many free things they are giving to everybody. And it's also frightening. We have got, 140 crore people. But as per the latest website, I saw that 88 crore people are going to get free food grains. Now you talk of old shirt and old clothes. After 75 years of the Constitution, if 80% of a population has to be given free food, then it's a very serious matter of concern. So I would say 10th schedule, I would say Article 282. I would bring back the right to property, not put it in 300A, put it back into Article 31. Yes, these are the things I would immediately do. And as far as the judiciary is concerned, I would put the collegium in the Constitution itself.
Again, that's another seminar that we can have. But let's have questions. There are many people here. Let's have questions.
Yes, you quoted the preamble as having the word socialist. So, till now, I have seen 2 to 3 enlightened and highly intelligent people questioning the socialist and communist ideology because they have been put under concentration camp, like what Hitler did in Germany. There were communist concentration camp, which one highly enlightened person suffered. And second is the question of Tibet. Tibet, you quoted Morris Friedman. Morris Friedman was in favor of giving independence to Tibet, but eventually that was taken out. So these, the 2 people that, one of them is Ayn Rand. There was a person called Ayn Rand. She questioned the ideology of socialism and communism and publicly told that it is a wrong ideology, but still our country follows that ideology.
Your question.
So how can you justify socialist word included in the constitution? I find no justification and it is very wrong.
Any freebie that is announced, it's clearly unconstitutional because you're preempting the Appropriation Act that should be passed by the legislature or the parliament later on. And these people, if they announce the freebies, they have already passed the budget. How can they do? I followed your arguments at that time, and I wrote to the Election Commission also that you must take a firm view on this. You must prohibit these freebies being given because you give the freebies without any resources in sight. You are destroying the basic structure of the government itself.
Yeah. In that case, the quote, and I refer to this Sadasivam and Justice Gogoi. So in the freebies matter, it was a bench of Justice Sadasivam and Justice Gogoi. And in the latter part, he recognizes that these freebies are vitiating the election, that it doesn't become free and fair anymore. And the matter was adjourned for some time to ask the election commission to see if they can pass something. They came back with a reply saying, unless all the parties agree, we will not do it. No party is going to agree. I think they should amend the law and ban it, or at least, then they asked, I said, you can keep the below poverty line, say basic, say 2 kilos of rice or something, that's perfectly fine. Yeah.
So that socialist point you want to...
No. On socialism, this was added by the 42nd Amendment. Secular and socialist was added in the Constitution, apart from various amendments. After the emergency, when Janata government came back to power, the 45th Amendment wanted to delete secular and socialist and also delete various other provisions. But Janata government did not have majority in Rajya Sabha. So the Congress said, we will not pass this constitution bill unless you agree to retain secular and socialist. So they retained secular socialist, and tragically they retained the chapter on tribunals. These three provisions Congress insisted as a bargaining thing to allow the 44th Amendment to go. So that's how secular socialist has been retained in the Constitution, because Congress refused to permit it.
I have two short questions. Two things have intrigued me about the creation of this constitution. One is, why was Mahatma Gandhi not consulted at all? Because as you rightly said, one answer would be that the constitution came into effect in the 1950s and Mahatma Gandhi passed away in 1948. But as you rightly pointed out, in mid-1947, there was a draft available. So why would somebody not take a draft constitution to the Mahatma and ask him, what are your thoughts on it? Because his thoughts on it are what Justice Ram Subramaniam said, the state of Aundh, where the king was called Bala Sahib. And he actually donated the entire state to his people and said, come on, go ahead and govern. In the constitution that is drafted, two things stand out. One is decentralization and the other is Panchayat Raj. Now, having expressed his thoughts on what a constitution would be, I'm very intrigued. Nobody went to him and consulted him on that. That's point one. Number two is, in the great research you have done in bringing out this book, why is there no mention of a political party in the constitution that was originally conceived? Till we had the 10th schedule, entire democracy rests on the foundation of political parties. And it's not as if political parties were alien, because we have already conducted elections with political parties. But the word political party does not figure at all in the constitution till the 10th schedule came. So these two have always intrigued me.
Sure. So I'll take that. On the first one, actually, I deal with it in quite a great bit of detail in the book itself as to why there's this absence of Gandhi in the constitution. I think it's a very complicated set of reasons, but to put it very simply, is that by the time we get to 1946, Gandhi himself is not that interested in a constitution. He is actually much more interested in ensuring that there's communal harmony, that the nation stays undivided. And he says, and he goes on record and says that the constitution is a mere policy document. A son cannot follow their father as a matter of policy. He said, I am only interested in making sure that we have good sons in India. So he is not interested as much in the framing of the constitution, number one. Number two is that, but you can still ask, what about Gandhians in the assembly? There are so many Gandhians in the assembly. Now, basically, again, to cut a long story short, the Gandhians in the assembly wake up very late to the fact that there is no Gandhi at all in this constitution. When they have woken up, not only has a first draft come from Benegal Narsingh Rao, Ambedkar has worked on the draft, there is a full draft that's there. And that is why I write in my book that I find it shocking that a freedom movement that is based on non-violence and satyagraha, the constitution doesn't use either of these words or their spirit even once. It doesn't use it. Because by the time they wake up, this draft has happened. So what happens then is actually something curious. Is that if the Gandhians say that no, it cannot be like this. So some ideas have to come in. So where do they come in? In directive principles. As prohibition, prohibition comes in, the village unit comes in the directive principles, cow slaughter, prevention of cow slaughter comes in, and then TTK makes a beautiful statement, is that he's become a dustbin of sentiment. He says it's become a dustbin of sentiment so wide that everyone can ride their hobby horse into it. Okay, so this is what happens to the directive principle. So that's what happens with Gandhi. He himself is not that interested in the constitution by the end of it. And as far as the second question on political parties, as in one, I mean, the cynical answer would be there was only one political party. I think the one envisaged really many political parties.
In a lighter vein, I used to say, a time will come when 10 schedule will go away. You know how? A political party will, with huge financial resources, will not nominate candidates to contest elections. They will sit on the fence, allow people to contest, and they will buy 350. Much easier option. Nobody has asked me.
A question there, please.
Yeah, first of all, thank you very much. It's been absolutely fantastic event for me. I don't live here, I live in Hong Kong, and to come here and thank you, ma'am, thank you, sir. The reason that we had such people of high quality wisdom who got together to write our constitution, is that the reason not to put anything in the constitution regarding what sort of people should be standing for elections and get elected as our representatives? Or shall we do something about it?
Well, maybe you have to first come back to India and become a voter. Yeah. Yeah, that is basically the electorate. So actually, this is a very interesting point that you mentioned, because one thing that I think is actually a remarkable feature about the Constitution is that they do away with all kinds of requirements of franchise. That every single adult, irrespective of literacy, irrespective of education, can vote. Something that was not even prevalent in the United Kingdom at that time, let alone the United States. And that is something that that everybody in the Constitution is ad idem on right from the get-go. And I think that's impressive. The second is that so recently there was a judgment of the Supreme Court in the case of Raj Bala, which was given by a bench of Justice Chalameshwar and Sapre, where there were restrictions in relation to who could stand for elections in local elections in Haryana. And there were three provisions that were put. One is that you should not have any dues on electricity bills and so on. So whoever stands must not have any dues to the government. Secondly, you must be a class 8 pass if you were a woman, and a matric pass, I think, if you were a man. And you must have a pakka toilet in your house. These were three restrictions that were put on who can contest elections. And the Supreme Court, in my view, rightly upheld those grounds by saying, and there were many arguments made that there are no restrictions like this for members of parliament and legislative assemblies, but there is a rational nexus. One, that you have to be a good citizen, and two, the fact that you have to have some basic level of literacy to be able to represent your constituency. So I think that as far as limitations are concerned, as I've always said, that I think we should not go down that path, as we are only as good as the people we elect, and we must hope that we live in a polity where people become more and more responsible.
We have a question here.
Yeah, thanks so much. It was a wonderful discussion, as you just said. And regarding the meritocracy argument that he was talking about, if I can just briefly say something before I ask my question. I would refer him to this book, The Tyranny of Merit by Michael Sandel. So this whole idea of meritocracy, I think he questions that, and perhaps that you
Not talking about meritocracy, he's talking about barring people with bad antecedents from contesting elections.
Okay. But I thought that who would be qualified to contest? No. Yeah.
Who would be disqualified?
Disqualified. Okay. Regarding the other interesting discussion, I have 3 points to make. One is about, you spoke about directive principles. And interestingly, Article 44 was not mentioned at all. So I wrote an article in the Hindu on this and said, in fact, why not rethink this article itself? Perhaps even consider repealing it if possible. Because from the time it was enacted till today, it has never been implemented, or even no draft has also been produced on that. So, which means that no political party has been able to even produce a draft. It means it's absolutely difficult. Although it was made in good faith and with a good intention, it would appear now that this is impracticable and impractical. So therefore, maybe there should be some rethink on that. The other part which I wanted to ask you was, the colonial word that you used in your book, perhaps what you actually mean is the authoritarian streak in the Constitution that the Constitution enables. I think it was beautifully exploited, the First Amendment. Uh, when it was presented in May 1951, the most vehement, strongest argument against it was by none other than Shyama Prasad Mukherjee, the founder of Bharat Jansangh, from which came the BJP. So interestingly, it was SP Mukherjee at that time who completely attacked Nehru on this First Amendment, and said that what if Congress is not in power and somebody comes and uses it, and I think we are seeing that today in a sense. So it was, interestingly and ironically, if you can say that, it was the founder of Bharatiya Jansangh which flagged this issue and said that this is where authoritarianism will come through into the country. So maybe you would like to say something on that. And if you can just add one more thing regarding the safeguards, as a minority, as a Muslim, lot of safeguards were there for the Muslims in the constitution. I mean, in before the India became independent. For instance, separate electorates, and Jinnah was also demanding proportional representation if that was not possible. But all these safeguards were taken away. And interestingly, a recent book by Prathina Vanil alleges, a book called Another India, alleges that most of or almost all the Muslim members of the Constituent Assembly were literally handpicked by Patel and others so that they would rather simply succumb to his demands. For instance, he calls Begum Aziz's Rasul a poodle of Patel, where for everything that was that should have been there as a constitutional safeguard for the Muslim was simply done away with. The Constitution didn't do anything. Ambedkar, who himself was demanding separate electorates for the Dalits, he didn't say anything about, because all these things were there before the Constitution came into effect. All these things were done away with. So why do you think this happened? Are these things, do these things also constitute something of the colonial mindset that later on came back? Thank you.
So just in very short, as far as the first point about the Uniform Civil Code is concerned and whether we should remove that directive principle, as in, I think that there needs to be a draft that is done. We ourselves, as a few colleagues and others, as in, have put out a draft of model family law reforms for discussion. This is not an issue in relation to backward practices in one community or the other, but it's actually a question of what modern family law in 21st century India should look like. So even the Supreme Court, which is going into this question of gay marriages, I mean, whatever it decides, and it can decide whichever way it wants to, the fact is that it will make no difference on the ground unless there is something like a code of this nature, which exists. So I think I would go the other direction. I wouldn't say that we should scrap it. I think we should make some effort, which was not made at the time of the drafting of the Constitution, though everyone was saying in favor of the Uniform Civil Code. No one ever saw a draft. So I think we should go in that direction and try and think up a draft that is genuinely workable in 21st century India. So that's number one. Number two, on the question of the First Amendment, as in, I don't deal with it in the book itself. There's an excellent book by Tripur Daman Singh called 16 Stormy Days about the history of the First Amendment. And you're absolutely right that the First Amendment actually really opens the floodgates to the Constitution becoming a pale shadow of itself. And I think that it's an act of great irresponsibility at that point of time because of some political compulsions, two political compulsions. One was the judgment in Champakam Doriarajam's case, which was a political compulsion out of a communal GO in Madras. Yeah, and the other was that Romesh Thapar and Crossroads and Brijbhushan and the RSS magazine, the mouthpiece organizer, and third was this right to property. But the point is that irrespective of any of this, the fact is, and I go back to what Chief Justice John Marshall had said, that this is not an ordinary law. It is a constitution you are expounding. So it's very critical to understand that political expedience should not mean that we can think of amending constitutions at the drop of a hat, but that was the precedent that was set, and that is what has happened. On the last question on separate electorates for Muslims and other safeguards, this is a much longer conversation. I think we'll just have it offline.
Only he has already mentioned about the First Amendment, which I mean I cannot justify the ninth schedule where you put something and it can't be challenged. It's and it's interestingly if you read Daniel Austin, this was the idea of VKT Chari from Madras. So but on this question of minorities and so on, I don't want to say Muslims or let's say all minorities. It's not correct to say there is no provision. 2930 are special protections for you, and Article 15.5, which I argued against and we lost for Justice Patnaik, was that all education institutions of minorities have no restrictions. You don't have the Right to Education Act. You need not admit students. 25% need not be admitted. So I don't think it will be a stretch to say that all the protections of minorities are gone. In fact, there are a lot of protections still there in this matter.
That's it. So we come to the end of this very, very interesting. We pride ourselves at the CIC that we are a spa for the mind and the soul. And I think today's discussion really opens up a number of subjects which can be debated, and we are thankful to the erudite panel to really have gone into areas which others might have dreaded to tread into. Well, whether it's an expedient constitution, colonial constitution, or an international constitution, I think you'll all have to read the book and form your own conclusions. But we at the CIC are very privileged that we had this conversation here and we had this erudite panel to really discuss and go into all these aspects. I'm sure all of you would have enjoyed this conversation, which really went into very fundamental issues which need much more intellectual debate and discussion. And we hope to bring such debates and discussions in future too. So thank you very much, sir, for joining us. And we hope to see you all more often in other events of CIC. Thank you very much.